Thing for victims, Mr. Speaker.
David Clendon.
Thank you, Mr. Speaker. Kia ora. Mr. Speaker, it's overall disappointing. Here we are, second to last sitting day of the year, middle of December, allegedly moving into the season of goodwill and good cheer, and here we are once again debating the latest iteration of this dismal legislation that seeks to somehow serve victims by punishing victims. Because we've heard a lot about victims' rights, but the people at the heart of this legislation, people in the state's custody whose human rights are abused, people who are mistreated while incredibly vulnerable in the custody of the state, are also victims. We're not hearing too much about those. This legislation and the preceding legislation seems to establish a hierarchy of victimhood, and frankly I don't accept that around something as fundamental as human rights. It's true that the Greens actually supported the initial 2005 legislation. We opposed it at first reading. We were persuaded to support it at third and final reading on the basis that it would be short-term, that it would have an expiry date. A sunset clause was built into it. And also that there would be a comprehensive overhaul, an inquiry into how do we deal better with victims and make our criminal justice system genuinely victim-centric, a genuinely restorative approach in which we can heal wounds, we can make some restitution to people and hopefully reduce the likelihood of reoffending. And I think the government ought to take pause to think. We've just heard from the gentleman who was the minister at the time this bill was in place, and his party using the yes. The party who initiated this legislation, the minister who led it, a party who supported it, who are now turned against it because it was an experiment. It may have had value for a short time in that very specific situation. Because Mr. Goss quite right, those offenders who were tortured in Mount Eden prison, and they were tortured, that was the finding of the court. They were not pleasant people. They were very, very tough people. They were quite, about as unpleasant as it can be. It was a unique one-off situation that this bill was responding to. The government is using as a justification for the embedding of this dreadful legislation as a permanent feature of our legislative canon that the public wants it so. It is suggesting that the public demands that prisoners must be given compensation and that prisoners ought never to receive any. I simply do not accept that. What limited research there is available tells us that the public is actually much less punitive than one would imagine if you'd looked at the corrections and other forms of legislation that have passed through this House in the last 10 years or so. Anecdotally, we all know, and I talk to people a lot about this stuff, about prisons and corrections and the like. And yes, you open a conversation about that, and immediately the knee-jerk reaction from people is, yes, it involves a lock indoors, throwing away keys. You scratch 1 inch below that surface. And New Zealanders actually are much more reasonable than that. New Zealanders will listen to a well-constructed argument. Very few offenders go away forever, only the worst of the worst. We know that most of the people in our prisons ultimately will come out. If the message we're giving those people while they're in jail is that you have no human rights, you have no right to receive compensation if your human rights are compromised by the state, what's that message telling them? That they are less than human, that they don't have the normal rights of a citizen. It's brutalising, it's dehumanising, and we will all suffer the consequences of that when these people are finally released back into society. The likelihood of those people being genuinely reintegrated back into mainstream, becoming good citizens, is much diminished if they're subject to this sort of legislation, the expectations that are built into this. The regulatory impact statement is a very interesting read, and I recommend it to anyone who hasn't read it. A series of options. Option 1, which is to allow the status quo, allow the existing legislation simply to expire. And the RIS tells us that in the short term that would expose the government, the state, to some financial risk. Inevitably there would be some further claims against the original legislation, but why don't we simply accept that risk, take that cost up front and then move on and develop some genuinely victim-based legislation. It is more that our integrity, our reputation as a country that acknowledges and respects human rights is worth a great deal more than any short-term cost that might be imposed if this legislation is allowed to expire. There have, after all, been only something like 25 awards that have been subject to victim claims since 2005, another 15 or so in the offing. We're talking about total figures of some few hundreds of thousands of dollars. In the scheme of things, it is rats and mice. It is not significant numbers, it is pennies. It is too cheap a price to sell ourselves out for, to sell our reputation and our integrity. So Section 48 of the bill, as I've said, suggests that we would be best to comply, or rather that letting the Act expire is the best way to ensure we comply with domestic and international human rights obligations, because this legislation has always been on incredibly shaky ground in terms of our human rights commitments internationally. The Convention Against Torture is the most obvious one, but not the only one. There have been some very tortured semantics brought to bear to say, well, yes, prisoners can get compensation, which is what the international agreement demands. But of course, we know in reality that this legislation endeavours to make it virtually impossible for any prisoner who is offended against to receive genuine restitution. It goes on to say that offenders, that this new option ensures offenders do not receive financial compensation for wrongful treatment without first having to redress the harm they have caused. And I have no particular problem with that. We're not opposed in principle to any money coming to prisoners being dispersed to their victims. But the way this is done, and Mr Cheval has outlined the exclusivity of this legislation, other forms of income for prisoners would not be subject to this. Why is it that we want to diminish the constraints on the Crown? There is no doubt that if this legislation is embedded, the likelihood of inmates bringing complaints, bringing cases against the Crown will be diminished, will be reduced. Why would an offender put themselves through the claim against the Crown, knowing full well that actually they won't get any significant financial redress if and when the Crown is found to have acted against their human rights? Money is not the sum total of restitution. And again, the model of restorative justice is highly sophisticated. It's complex, it's hard, it takes time. But it ultimately is where we need to go. We need to go to a genuinely restorative place. Extending this bill extending the life of this legislation, making it permanent, takes us further away from that place. It is a short-term fix, now treated as if it's a long-term solution, which it patently is not. One remarkable new feature of this bill is that it talks about the illegal or wrongful detention or false imprisonment of people, and now how that will be not only from here on come under the ambit of this bill, but it's been made retrospective as well. Retrospective legislation is seldom good legislation. It has its place, a very limited place, and this is not one of them. It is extraordinary to suggest that a person who has been kept in prison longer than the court decreed they ought to will, if they successfully claim against the government, against the Crown, that any financial redress will also be subject to this new law. It's an odd. If it goes on to say, if the courts found unlawful detention claims should not have been subject to the PVC Act, that is retrospectively, the Crown may be liable for some payments made in accordance with the Act. This sort of reflects the consultation, if one can call it that. Corrections Department, understandably. Ministry of Foreign Affairs and Trade. I'm puzzled as to why. They were one of the very privileged few who had opportunity to submit. The Treasury. This bill reeks of risk aversion in terms of saving that last dollar. It is willing to sell out our integrity, sell out our reputation as a country that respects human rights for everyone, and I think the price is far too high. We'll continue to oppose this bill. Thank you, Mr. Speaker.
Cam Calder.
Pleasure to take a